Back at chapter 4, new section 4, chapter 4, of the performance of contracts which must be performed. 37, obligations of parties to contract. The parties to a contract must either perform or offer to perform their respective promises unless such performance indispensed with or excused under the provision of this act or of any other law. Promises bind the representative of the promisor in case of the death of such promisors before performance, unless a contrary intention appears from the contract. 38, effect of refusal to accept offer of performance. Where a promisor has made an offer of performance to the promisee and the offer has not been accepted, the promisor is not reasonable for non-performance, nor does he thereby lose his rights under the contract. Every such offer must fulfill the following conditions. 1, it must be unconditional. 2, it must be made at a prior time and place and under such circumstances that the person to whom it is made may have a reasonable opportunity of ascertaining that the person by whom it is been made is able and willing there and then to do the whole of what is bound by his promise to do. 3, if the offer is an offer to deliver anything to the promisee must have a reasonable opportunity of seeing that the thing offered is the thing which the promisor is bound by his promise to deliver. An offer to one of several joint promises has the same legal consequences as an offer to all of them. 39. Effect of refusal of party to perform promise wholly. When a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. Acquiescence is quiet, like being silent. I'm not going to do all that. 40. Person by whom promises is to be performed. If it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be performed by the promisor himself, such promise must be performed by the promisor. In other cases, the promisor or his representative may employ a competent person to perform it. 41. Effect of accepting performance from this person. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. 42. Devolution of joint liabilities. When two or more persons have made a joint promise, Then, unless a contrary intention appears by the contract, all such persons during their joint lives and after the life of any of them, his representative jointly with the survivor of survivors, and after the death of the last survivor, the representatives of all jointly must fulfill the promise. 43. Any one of joint promisors may be compelled to perform. When two or more persons make a joint promise, the promise may, in the absence of express agreements to the contrary, compel anyone or more of such joint promisors to perform the whole promise. Each promisor may compel contribution. Each of two or more joint promisors may compel every other joint promisor to contribute equally with himself to the performance of the promise, unless a contrary intention appears from the contract. Sharing of loss by default in contribution. If any one of two or more joint promisors make default in such contribution, the remaining joint promisor must bear the loss arising from such default in equal shares. Explanation: nothing in this section shall prevent a surety from recovering from his principal payments made by the surety on behalf of the principal, or entitle the principal to recover anything for the surety on account of payment made by the principal. 44. Effect of release of one joint promisor. Where two or more persons have made a joint promise, a release of one of such joint promisors by the promisee does not discharge the other joint promisor, neither does it free the joint promisor so release from responsibility to the other joint promisor or joint promisors. 45. Devolution of joint rights. When a person has made a promise to two or more persons jointly, then unless contrary intention appears from the contract, the right to claim performance rests as between him and them, with them during their joint lives, and after the death of any one of them, all the representatives of such deceased person jointly with the survivor or survivors, and after the death of the last survivor, with the representatives of all jointly. Time for performance of promise, where no application is to be made and no time is specified. Where by the contract a promisor is to perform his promise without application by the promisee, and no time for performance is specified, the engagement must be performed within a reasonable time. Explanation: the question, what is a reasonable time, is in each particular case a question of fact. 47. Time and place for performance of promise, where time is specified and no application to be made. When a promise is to be performed on a certain day and the promisor has undertaken to perform it, I'm gonna read it over. When a promise is to be performed on a certain day and the promisor has undertaken to perform it without the application by the promisee, the promisor may perform it at any time during the usual hours of business on such day and at the place at which the promise ought to be performed. 48. Application for performance on certain day to be at proper time and place. When a promise is to be performed on a certain day and the promisor has not undertaken to perform it without application by the promisee, it is the duty of the promisee to apply for the performance at a proper place within the usual hours of business. Explanation. The question, what is proper time and place, is in each particular case a question of fact. 49. Place for the performance of promise, where no application to be made and no place fixed for performance. When a promise is to be performed without application by the promisee and not place is fixed and no place is fixed for the performance of it, it is the duty of the promisor to apply to the promisee to appoint a reasonable place for the performance for the promise, and to perform it at such a place. 50. Performance in manner or at time prescribed or sanctioned by promise. The performance of any promise may be made in any manner or at any time which the promisee prescribes or sanctions. The performance of any promise may be made in any manner or at any time which the promisee prescribes or sanctions. 51. Promisor not bound to perform unless reciprocal promisee ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, no promisor need promise. Note, I'm going to read that one over. When a contract consists of reciprocal promises to be simultaneously performed, no promisor need perform his promise unless the promisee is ready and willing to perform his reciprocal promise. 52. Order of performance of reciprocal promises, where the order in which reciprocal promises are to be performed is expressly fixed by the contract, they shall be performed in that order. And where the orders is not expressly fixed by the contract, they shall be performed in that order which the nature of transaction requires. 53. Liability of party preventing event on which contract is to take effect. When a contract contains reciprocal promises and one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from the other party for any loss which he may sustain in consequence of the non-performance of the contract. 54. Effect of default as to the promise which should be performed in contract consisting of reciprocal promises. When a contract consists of reciprocal promises such that one of them cannot be performed, and that its performance cannot be claimed until the other has been performed, and the promisor of the promise last mentioned failed to perform it, such promisor cannot claim the performance of the reciprocal promise and must make compensation to the other party to the contrary for any loss which such other party may sustain by the non-performance of the contract. 55. Effect of failure to perform a fixed time in contract in which time is essential. When the party to a contract promises to do a certain thing at or before a specified time, or certain things at or before a specified time and fails to do such thing at or before a specified time and fails to do such thing at or before a specified time, it was like twice, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was at times should be of essence of the contract. Effect of such failure when time is not essential. If it was not the intention of the parties at time, that time should be of the essence of the contract. The contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned by him by such failure. Effect of acceptance of performance at time other than agreed upon. If, in case of a contract voidable on account of the promisor's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than agreed, the promisee cannot claim compensation of any loss occasioned by the non-performance of the promise at the time agreed, unless at the time of acceptance he give notice to the promisor of his intention to do so. 56. Agreement to do impossible act. Agreement to do impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards become impossible or unlawful. A contract to do an event which, after the contract is made, becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to be something which he knew or with reasonable diligence might have known, and which the promisee does not know to be impossible or unlawful, such promisor must make compensation to such promise for any loss which such promisee sustains through the non-performance of the promise. 57. Reciprocal promise to do things legal and also other things illegal, where persons reciprocally promise firstly to do certain things which are legal, and secondly, under specified circumstances, to do certain other things which are illegal. The first set of promise is a contract, but the second is a void agreement. 58. Alternative promise, one branch being illegal. In the case of an alternative promise, one branch of which is legal and the other illegal, the legal branch alone can be enforced. 59. Application of payment where debt to be discharged is indicated, where a debtor owing several distinct debts to one person makes a payment to him either with express intimation, or under circumstances implied that the payment is to be applied to the discharge of some particular debt. The payment of accepted must be applied accordingly. I gotta look that up. We had to look that up. Intimation, civil law. The name of any judicial act by which a notice of a legal proceeding is given to someone, but it is more usually understood to mean the notice or summons which an appellant causes to be given to the opposite party, that the sentence will be reviewed by the superior judge. So I'm going to read that one over. And where a debtor, so 59, application of payment where debt to be discharged is indicated. Where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implied that the payment is to be applied to the discharge of some particular debt, the payment of accepted must be applied accordingly. 60. Application of payment where debt to be discharged is not indicated. Where the debtor has omitted to intimate and there are no other circumstances indicating to which debt the payment is to be applied, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, whether its recovery is or is not barred by the law in force for the time being as to the limitation of suits. 60. Application of payment where neither party appropriates. Whether neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, whether they are or are not barred by the law in force for the time being as to the limitation of suits. If the debts are of equal standing, the payment shall be applied in discharge of each proportionability. 62. Effect of innovation, rescission, and alteration of contract. If the parties to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. 63. Promise may dispense with or remit performance of promise. Every promise may dispense with or remit, wholly or in part, the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. 60. Consequence of rescission of voidable contract. When a person at whom option a contract is voidable rescinds it, the other party thereto need to perform any promise therein contained in which he is the promisor. The party rescinding a voidable contract shall, if he have received any benefit thereunder from another party to which contract restore such benefit, so far as may be to the person from whom it was received. 65. Obligation of person who has received advantage under void agreement or contract that becomes void. When an agreement is discovered to be void, and when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. 66. Mode of communicating and revoking rescission of voidable contract. We have rescission. We busting their ass up with rescission. Excuse my language. The rescission of a voidable contract may be communicated or revoked in the same manner and subject to some rules as applied to the communication and revocation of the proposal. 67. Effect of neglect or promise to afford promisor reasonable facilities for performance. If any promisee neglects or refuses to afford the promisee reasonable facilities for the performance of his promise, the promisor is excused by such neglect or refusal as to non-performance caused thereby. Man, we at chapter 5 when we come back.